Hello and welcome. We've all had that feeling, staring at a huge contract, totally terrified of the fine print. It feels like this secret code, right? Like it's designed to trip you up. But what if I told you that what's written down isn't always the last word? Today, we're going to pull back the curtain on the hidden world of contract law. We'll find out how courts figure out what a contract really means and what happens when a deal is just plain unfair. So let's just start with the big question right up front. Is a signed contract set in stone? Once you sign on that dotted line, is it completely locked in, no changes allowed? Well, you might think the answer is a simple yes, but the law is actually way more flexible and honestly a lot more interesting than that. Okay, so the traditional starting point for any court is something called the Four Corners Rule. The idea is really simple. A judge should only look at what's written inside the four corners of the actual document. If it's not on the page, it basically doesn't exist. This whole approach is meant to create certainty, so everyone knows where they stand. Now, this idea is backed up by a pretty formal-sounding legal rule, the Parole Evidence Rule. All this really means is that once you have a final written contract, you can't just bring in other stuff like notes from an old conversation or an email to try and change the deal. It's the law's way of saying, hey, let's stick to the final script, okay? But, and you probably saw this coming, there's a big but. Because let's face it, real life is messy. It's almost never as neat and tidy as a legal document. And the law actually gets that. So that solid wall of the Parole Evidence Rule, it's actually full of cracks. Lawyers call them exceptions, and they're super important. They're what lets outside evidence in when the written words just don't tell the whole story. So what are these exceptions? Well, they cover all sorts of situations, like when the contract's wording is really unclear, or it seems like a piece of the agreement is missing, or maybe you agreed verbally on when the contract would actually kick in. But honestly, the most fascinating one, I think, is custom and usage. This is where the normal way of doing business in a particular industry can totally flip the meaning of the words on its head. Let me give you a classic example to show you what I mean. Imagine you sign a contract to buy 1,000 rabbits. So how many rabbits would you expect to show up at your door? 1,000, right? It seems obvious. Well, believe it or not, a court in England had to decide this exact question way back in 1832. And here's the twist. The court actually allowed evidence that showed that in that specific part of the country, it was just local custom that the phrase 1,000 rabbits actually meant 1,200. How wild is that? It's the perfect example of how context is everything. The normal way of doing things in that trade completely changed the meaning of the words right there on the page. This whole idea of looking at the context has really evolved over time, and it's led to the modern way of looking at contracts. So instead of a super strict, literal reading, courts today try to figure out what the people signing the contract were actually trying to do. They look at the deal with, commercial common sense. And this is the key insight right here. Courts now recognize that, hey, people aren't perfect. We make mistakes. We use the wrong word or phrase things kind of clumsily. And in those situations, a judge can step in and basically correct the language, as long as all the background information makes it super obvious what the parties really intended all along. Judges actually use this hilarious literary example to explain the idea. It comes from a character, Mrs. Malaprop, who was famous for messing up her words. So when she talks about a headstrong allegory on the banks of the Nile, nobody's confused about what an allegory is. The context makes it perfectly clear she meant to say alligator. And the law, believe it or not, works pretty much the same way. This common sense approach was actually summed up beautifully by a famous judge, Lord Hoffman, into 5 key principles. It's like a judge's toolkit. Basically, a judge should look at the contract like any reasonable person would. They should consider all the background facts, the whole factual matrix, as it's called. They need to get that people sometimes use the wrong words, and this is the big one, if the literal meaning leads to a crazy result, the law doesn't force them to go along with it. And this quote from another judge, Lord Diplock, just hammers the point home. He's saying that if you do a super detailed, nitpicky analysis of the grammar and it leads to a conclusion that makes zero sense in the real business world, well, common sense has to win, period. Okay, but what happens if a contract is perfectly clear, but it's also brutally one-sided? So now we're going to pivot a little bit. We're moving from the question of what a contract means to the question of, is it fair? Can the law actually step in when a term, even if it's written in plain English, is just fundamentally unjust? And the answer is a big, resounding yes, thanks mostly to this really powerful piece of law, the Unfair Contract Terms Act of 1977, or UCTA for short. You can think of this act as a shield. It protects people, especially in business deals, from clauses that try to unfairly limit or completely get rid of responsibility when one side messes up. The heart of UCTA is what's called the reasonableness test, and this is really important. The test isn't about whether it's reasonable to use the clause now that something has gone wrong. The question is much more fundamental. It's looking back at the exact moment the contract was signed. Was this a fair and reasonable thing to put in there in the first place? And honestly, there's no better way to understand how this works than with a real-life story. This is the case of George Mitchell versus Finney Locks Seeds. And it all started with a really simple transaction, a farmer buying some winter cabbage seeds. The total cost for the seeds was just under 200 pounds. A pretty small amount in the grand scheme of things for a commercial farm. But here's where it all went wrong. There was a catastrophic mistake. The seed company sent the completely wrong kind of seed. It was a variety that was totally useless. The farmer planted 63 acres, and the entire crop, the whole thing, was a total loss. The farmer's financial hit was just staggering. Over 63,000 pounds in losses. All of that gone because of one small bag of the wrong seeds. So, of course, the farmer sued. But the seed company pointed to a clause buried in the contract. And it said that if anything went wrong, the most they were liable for was the price of the seeds, just 200 pounds. A tiny, tiny fraction of the actual damage they caused. This case went all the way to the top, to the House of Lords, which was Britain's highest court back then. And their decision was powerful and clear. That clause was unreasonable. The judges looked at a few key things. The seller was negligent. They could have easily gotten insurance for this kind of risk without jacking up their prices. And, get this, it was common in the seed business to not actually enforce this clause, but to work out fair compensation instead. So what's the big takeaway from all this? Well, it's that a signed contract is not some unchangeable stone tablet. It's a living document. It has to be understood in its real-world context. Courts have the power to look past the literal words to find the true meaning, and they can absolutely strike down terms that just fail a basic test of fairness. And that leaves us with one last really important question to think about. Businesses need certainty to operate, but society demands fairness. These two powerful ideas are always in a bit of a tug-of-war in the law. So where do you think that line should be drawn? Thanks for joining me for this explainer.